Many of you are not going to like the sound of this video, and it's certainly not going to be music to your ears, and it might even drive you mad. That's because I'm talking about driving whilst changing the music on your phone that plays through your Bluetooth speakers. Now, many of you will realise that it is an offence to be using your mobile phone for communication purposes whilst you are driving. That is thanks to Regulation 110 of the Construction and Use Regulations of 1986. Regulation 110 states that no person shall drive a motor vehicle on a road if he is using a handheld mobile telephone or a handheld device of a kind specified in paragraph 4. Jumping down to subparagraph 4, it says that a device referred to in those paragraphs is a device other than a two-way radio, which I'll come back to in another video, which performs an interactive communication function by transmitting and receiving data. Now, it's the wording in the very end portion of that paragraph that is going to upset a lot of people in this video for reasons I'm going to explain now. So, using your mobile phone for any kind of communication by transmitting or receiving data, that is any kind of data information on the phone whatsoever, is an offence under these regulations. However, one such convicted individual tried to challenge this. You see, in this case, a driver was using his mobile phone to change the music that he was listening to, which he was listening to via Bluetooth connectivity on his car. So his phone was receiving the music, presumably from one of the major music providers, and transmitting it to his car via Bluetooth. He then changed the music that was playing on his phone and was convicted under the Road Traffic Act and these construction and use regulations, which prohibited the use of mobile phone as I've just set out. He appealed his conviction by way of case stated. That means the court states the case and tells the appeal court what happened in the case and the question of law that the appeal court has to answer. So by doing this, he challenged the magistrate's decision to convict him of this offence to state that he was only using his mobile phone to change the music whilst he was driving his car. And in making his appeal, he said that the interactive communication function had to involve communication with another person. And thus, as he was only changing the music in his car, said that he should not have been convicted of this offence. And his second point, that it was he, the user of the mobile telephone, who was communicating, not the device. And that the transmission of data in the form of music from the telephone to the user did not amount to an interactive communication function. However, this appeal has been dismissed, with the court saying that the ordinary and natural meaning of the words in the regulation did not require communication to be with another person. And this was because, in theory, messages could be sent to or from an automated messaging service which didn't involve any human, and that internet communication frequently does send and receive data from a server without any human involvement, whether this is direct or indirect. The court also said that the communication via Bluetooth between the phone and the car was a form of communication via radio waves, and that the music data on the mobile telephone was sent to the car system and thus was an interactive communication. Thus, the court said that he was using an interactive communication function, and the communication may well have been one way, but the communication itself was entirely sufficient. Thus, his telephone had interacted with the car's Bluetooth system. Thus, the court dismissed his appeal, upheld the conviction, and held that he was committing an offence pursuant to Regulation 110, thus was rightly convicted. Thus, if you are listening to music in your car via Bluetooth and you change the song that's playing by touching your mobile phone, you are committing an offence just as if you were sending a message to another person. This according to the Queen's Bench Division of the Administrative Court, which has dismissed this appeal on this very point raised. So as I said, many people are going to be upset by this because you now cannot even change the music that you're listening to by selecting options on your phone, because this would amount to an offence, just as if you're using your mobile phone to send a message to somebody else or to make a phone call, which under these regulations you're not permitted to do. So as always, let me know in the comments what you think of this. Please remember to like the video and subscribe for more of these updates. Make sure you hit the bell icon so you receive notifications of new videos, and as always, thank you for watching.